Good morning. Howard, like myself, is a transplant to Iowa City. Your grandchildren. 2-year member. I'm a 3-year member or 2.5-year member. So I'm filling in for Paul this morning, who was in Boston with family, and that's exactly where it should be. As a realtor of 44 years, our market started at the womb and ended at the tomb. And in between there was all kinds of events that created a desire to buy a home, sell a home, not buy a home, sell a home. And so at the tomb, I saw some interesting things that went on with families that were not very good. So what Howard is going to talk to you about today is something that's going to eliminate some of the true gnashing of teeth that I've seen when families have to deal with death and the consequences of it. I've been in courtrooms giving opposing appraisals to families that fight over the values. I've been in courtrooms having judges sign documents so the family could dispose of homes. I've seen a little bit of all of it. And Howard has the expertise that he's going to share with you how to avoid some of those things. And we'll open with prayer. Heavenly Father, you are a guide in our lives in all ways. Fill this room with the Holy Spirit with a desire of wisdom and love and learning. And one subject that is repeated in the Bible many times, the stewardship of everything that you give us. Everything belongs to you, is yours. We only steward it. To guide us and deliver wisdom in our hearts from your Son, Jesus Christ. Amen. I'll let Howard.
Thank you, Jay. Well, I'm going to talk about 4 different subjects, and they're going to maybe 10 minutes each. Maybe I can shorten it down because we're getting a late start and whatnot. But one is going to be wills, the other one is going to be beneficiaries, and the other one is going to be trust. And you can throw all your assets that you've gathered over the years into one of those categories, or all 3 of those categories, and that would be of help. And I'll give you the pros and cons of why you might want to do that. The other aspect is going to talk a little bit about power of attorneys, and we've got a funeral document also that the church has recently made. So anyway, I'm going to talk this week about just the wills and the estate planning aspect of it. And then next week, I'm going to talk about the tax efficiencies associated with how you can invest your money and or give your money to the church in a very tax efficient way to both help the church out and also to help you out on that. So I had to start out with Franklin's quote, but anyway, it's really quite an emotional issue dealing, and it's really deep emotions, and then it's also a number of assets that you have, and it's also just law. So I'm going to be able to concentrate on the law and the assets you have type briefing, but the deep emotions of grieving and all of this aspect, I'm going to have to just kind of say, well, you're going to have to deal with that on your own because everybody grieves in a different manner. And I know that to be true. So the first thing is, who's going to inherit your various things? And this is the definition of what the will is. It's just a written document, and it just says who gets what on that. And I'll go into the deal. Now, do you have a will? Everybody raise your hand. Just keep it raised. And even if you didn't raise your hand, yes, you do have a will. You didn't realize that. Well, 72% of the people don't have a will in the United States based on surveys, and it's getting even worse. As it keeps growing, more and more people don't have a will whatsoever. So the state has a will for you, and Iowa has a will for you. You didn't know that, but if you don't like it, and I'm going to tell you a little bit about that, you do have a will. I don't necessarily like that will, and you might not like that will, but Iowa has one for you. And this is what happens. If you die with a will, then you can select a category of where you are on here. The children but no spouse, child inherits everything, etc. And I don't know how many people are married, and I don't know how it affects you. The only one that's a little bit complicated is if you've already been previously married, and then now you're divorced and you've got another marriage, but then you had kids in the first marriage, and now you have kids in the second marriage. The state, in essence, says this, that your spouse will inherit half of it, your real estate, and then the other half goes into your personal property. And they have to have at least $50,000. The current spouse has to get at least $50,000 on that. Now, if you have a will, this is forget it. And in fact, I would prefer that you have a will and not have the state do it, simply because you can give other things to church, you can give it to charities, you can give it to all kinds of different people on that. But anyway, if you make a will in Iowa, these are the requirements that you have to make. And a lot of people will go online and make a will, and they don't want to pay the $100 to $300 that it requires to make a will. If it's a very simple will, it only costs that much. Now, if you have a lot of property in different states, and you have 3 or 4 homes all throughout, or you're a millionaire, you probably shouldn't be belonging to this briefing whatsoever, because it gets really complex pretty quickly in terms of making your will out. But anyway, you got to be 18 years old or married. Now, I don't know how many people would be under 18 and married, but nevertheless, some people are. The maker has to be of sound mind. I've never seen anybody ever challenge that and win the sound mind aspect of a will. But nevertheless, some people do win, I guess. You have to be, it has to be written and signed in the presence of 2 witnesses, and the witnesses have to be 16 years or older, and they really can't be immediate blood relatives. I won't go into the definition of immediate blood relatives, but there is a very well defined. So it's better not to have a witness that's a relative in essence, so you get in trouble. And you have to tell, and this is really weird, when I had my will made when I first moved here 2 years ago to Iowa City, you have to tell the witness that this is my will, so that they know that when they're signed, they don't have to read the will or anything, but they have to know that it's my will that they're assigning witnessing. I'm not sure why the state of Iowa has that rule, but that's the rule. And then you'd have to do an executor of your will. And when you make a will, the person, in essence, that is in charge of your will is called the executor. And sometimes if you have a trust, and I'll talk about trusts a little bit later, that's called a trustee. So there's 2 different requirements for executors versus trustees on that. But anyway, that's, and I'll go into a lot more detail. It's really kind of critical in terms of you deciding who your executor is going to be. Most people, if they have family, they're older, a little bit older, and they have kids, and their kids, and when I say kids, they're really adults, but nevertheless, I still call my kids kids on that, even though they're in their 40s now. But nevertheless, you have to have someone be your executor. And a lot of times, to be an executor, you have to be a little bit talented, but the most important talent, more than anything else, is your ability to be able to communicate and your ability to involve all of the different heirs so that you could talk to them. And if you can't talk to them, you don't want that person to be your executor, because then you get into all kinds of problems with family, arguing with family about different things, and the executor and involving the courts and all this other items. So it's kind of key to, and I'll go through a little bit more about the executor on that. Now, there's some things that you've got to leave out of the will, and it's kind of important. If you have a child, you don't want to say, well, I give all my money to my child. Well, your child, now I'm talking about truly child, I mean somebody that's under 18, they don't really know enough about finances to be able to properly invest that money, and the executor would have to do it for them. And so it's better to have it be put into a trust or be put somewhere where somebody, a fiduciary of some sort, would be able to manage that money until that child reaches a certain age. Now, from my own personal experience, we've developed a trust where we said, okay, our children will get the money, a third will be at 25, and then 30, and then 35 by thirds. Fortunately, nobody died that early, and so therefore, the trust was worthless. But nevertheless, that's what happened with our trust on that. Non-probate assets, I'll talk in a little bit about that. Terms that leave the fixed or higher, unrealistic dollar amounts. You don't want to say, I'm going to give $50,000 to this person or this church, and then all of a sudden the market crashed and there's only $25,000 left in your estate. Well, guess what? That person of the $50,000 is going to get that money, and then so you don't want to do that. You want to give them a percent of the estate, 10% of your estate or something like that. You don't want to say a specific dollar amount because you don't know when you're going to die, and you don't know how much your estate is going to be worth of all your assets and things of that nature. And you don't want to give conditional gifts. You don't want to say to your child, well, if you don't marry John because you don't like him, then you'll get this money. But don't do that. Or even worse, well, if you get off these drugs and you pass certain drug tests, then you get this money, or you can go crazy in terms of, well, you don't want to make conditional gifts like that in your will. It's just not worth it. You could do it a little bit differently where you control it still with a trust, and that would be perfectly fine to do that, but you don't want to do that in a will. Secure information, all wills can be published and gathered by anybody that cares to do that. And so you don't have any privacy when you do a will. So you might want to think about that. You don't put your social security number down on a will. Don't put your passwords or all this information that somebody else can take and use. You don't want to do any of that in a will, in a published document that's available to everybody.
So it's essentially public. A will is public?
A will is public. Once you die, it's
Okay.
public. Yeah. Once it goes into probate, the will is public. And you'll get a lot of people. I've been an executor, 6 different people, and you get a lot of weird scam artists that take advantage of that information, and you just don't put anything in a will that you care to have somebody else know about. And I'll talk a little bit more about that. Secure information, again, you don't want to put your, and I'm not an expert in this other than Facebook. I'm not even an expert at Facebook, but TikTok and all these different media organizations have passwords and things like that. And there's a current law now that was developed by Congress in 2015. And the way to do that is just type up a piece of paper and then give it to your heirs and say, okay, here's my passwords to all my different accounts that I have. But you don't want to have any knowledge of that in a will or anything like that at all. I mean, it's just, it really is much more subject to abuse. Even though you're dead, there's still abuse that people could write on your Facebook account and say, you think this, and even though you're dead, that you think this or that or whatever. You know, it's beyond me. Funeral instructions, you don't want to put funeral instructions in there, because by the time it gets to probate and the will to the court, where they actually prove that it is your will, and I accept that it's your will, and therefore you're the executor, before that happens, you got to bury the person. So any funeral instructions you have, and in fact, that's why I'll hand these out. So small print and large print. It's much better to use this type of document that the church has made for funeral and all those other things for your planning for funeral instructions. So if you need funeral instructions, don't put it in your will at all. Guns are a really special category. And I got caught in this a little bit on some of the estates that I've had to be executor for. But federal law and state law is just too much for you to handle in a will. So if you can do this before you think you're going to die, and you're a gun collector, or just have a few shotguns or whatever for hunting purposes or whatever you've had, try to give it away before you die. I know that's hard to say, because technically the executor can't really say, oh, well, here, John, this is yours, this is your gun, so take it away. But the executor then says, the executor then is held accountable for, did you follow the federal laws associated with gun control? And most likely not. And did you follow the state of Iowa laws associated with gun control? And most likely not. So guns are a special category. Now you can put them in a trust, especially if you're a collector of guns and you have all these bizarre weapons associated with everything, and you want to keep it and they're worth quite a bit of money. I mean, weapons are worth quite a bit. I mean, just a shotgun is worth quite a bit. And then disparagement to the, don't say, well, I don't like my daughter because we never got along and I don't like her at all, and so therefore I'm giving her nothing. Go ahead and say, unbeknownst to me, or for my own knowledge, I just don't want to give my daughter nothing. But don't say why you don't want to give your daughter nothing, or whatever. I mean, it's a public document, and you just don't want to do it. And then business interests is really, really complex. If you own businesses, you really should have already a document associated with that business and not make it a part of your will, simply because there's employees involved, there's maybe loans involved with the businesses, and it depends on the type of business you have, whether it's a partnership, an LLC, just you shouldn't really have that in the will.
Did I miss what you said on number 3 about non-probate assets?
Yeah, I'll talk about that right now. Thank you. That's a good lead-in. Non-probate assets. The ideal category, again, you have wills and you put your assets in wills, and you put some of your assets in beneficiary type documents, and then you put some of your assets into trust. And the ideal thing, and it's free, is doing beneficiaries. So if you have life insurance, automatically go and to your life insurance company, and you probably already signed this document of setting it up. Or if you have IRAs, traditional IRAs, if you have Roth IRAs, if you have 401Bs, if you have 403Bs, if you have 457s, anything dealing with stocks, bonds, anything like that, it's a beneficiary. And put it as into a beneficiary, and then the beneficiaries immediately get it, and it's not probate, and it immediately goes to your beneficiaries after you get a death certificate. And I'll talk a little bit about that. So sometimes they want just anymore now, they'll accept a death certificate online, and it doesn't have to be sealed and signed and all this other stuff. But some of them get a little picky. Banks are a lot of times a little picky about that, especially safety deposit box. They get really picky about that. But anyway, you have to, you want to try to sign these things to the beneficiaries so that they get the money immediately, and it's up to them, to the heir that has been assigned as beneficiary, for them to deal with it, and the executor no longer has to deal with it through a will. And even better yet is that you don't have to deal with it through the probate, which makes it non-private, and this would be more of a privacy type issue also. So it's quicker, and it's non-private, and there's no fees involved through a court process. So it's better for, if you could possibly do it, put everything in a beneficiary type thing. Or if you don't have beneficiary forms for all of this stuff, then you can start talking about trust, which I'll do in a second. And you can put them in trust documents, which then it's no longer, as an executor, it's more like a trustee that handles the trustee, and they have fiduciary responsibilities. They have to document every 3 months, et cetera. You know, Jack? Well, anyway, so now, me personally, I've made it so that when I die, I don't need a will. I mean, I got one, but I have no money in it other than my car. For some reason, the state of Iowa, which is different than a lot of other states, you can't do a transfer on death for your car. I don't know why Iowa is this way, but it is. So, but more importantly, is that if your estate is less than $25,000 to include your car and all your items in your house or whatever that you own personally, you can just ask the judge to just declare it, and you can just get rid of it right away, and there's no probate necessary for that. So when I die, there's no probate at all. My wife doesn't have to do any probate whatsoever, and everything else is in these documents for my kids and my wife and whatnot. And I used to have trust when my kids were younger, but I'll talk about that in a second. So, as a 6-time executor and as an advisor to probably another dozen people that have died, to their executors, or advisors to people that want advice as to who should be their executor, these are some of the problems that you have. The first one is delay. If the person has absolutely no experience as an executor, there's going to be a lot of delay associated, because there's going to be a big learning curve associated with that person, so that's one issue. Sometimes the executors pay out the funds too early because there's pressure from the heirs, and they don't realize that with courts involved and et cetera, that if you can get an estate done within 1 year, you're lucky. Now, COVID years, 2020, you couldn't even get a court hearing because the courts had shut down except for the most critical ones. And guess what? Probate wasn't very critical in terms of the court size. And so therefore they would handle the criminal courts or things of that nature that they felt was more important in the COVID year. So 2020 was really a bad year for people that dealt with courts and probate. And it would be a good year and a half before they could start going. And meanwhile, all of that money, assets in your estate has to be managed, and it couldn't be managed because you hadn't really gotten through probate yet that says, yeah, that's a valid will, and yes, you are now a valid executor and manage this money. So you're sort of in a limbo type mode. So that happens. You have to file taxes for the person that died. I have expertise in taxes, so I could do all this stuff. But some people don't have that expertise. So you have to make sure that the document, the will that you have, for example, the will that I just signed 2 years ago when I moved here, it was like 4 pages of executor. Executors could do 4 pages of different things if they wanted to do it. And hire people, do things, you know, if you don't have income tax expertise, you could hire somebody to do income tax. If you don't have expertise in selling your property, you could have somebody sell your property for you, you know, things like that. And then you have not following the terms of the will. That's just a big mistake. Please don't do that. If you're an executor or if you sign somebody, don't make sure that they follow the terms of the will, because that's the legal document that's associated with that. This one, the failing to provide all asset information, that's happened several times simply because people make mistakes or they forget. My dad, he forgot he had some stocks, and he did a really good job, as did all of the people that I dealt with. They did a good job of articulating what their assets were, but they forgot on some things. So he had some stock certificates, and this was in the days when he actually had the stock certificates in his safe. So we had to go in and try to figure out, okay, what were these stocks worth when he died for capital gains purposes, and it was kind of a nightmare. It took me about a year because I didn't have internet back then, and so I had to write letters to various companies to say, well, how much is this stock worth, and how much was it worth when my dad died, and et cetera, to get capital gains tax. So it took a good year to do that. The biggest thing, more than anything else, is the failure to communicate to the heirs. There are more controversies associated where people get upset. That's probably too weak a word, but they want to sue. They want to do everything they can because you as the executor didn't communicate to them. They didn't even communicate that here is a copy of the will, or they didn't communicate every month. I did it every month, and then I would do it with the internet and everything. I would just email everything that I did, and then they could comment, and then they could trust me in essence that I was doing a good job as executor, looking out for both them and myself as an heir. But that is probably the biggest failure of all. And then sometimes confusing probate assets. Remember, I was talking about probate assets and beneficiary assets. Well, beneficiary assets are good. Then the beneficiary person has to go and try to gather that money, and all they need is a death certificate to be able to do that to the various people or various organizations that have that money. But sometimes they say, well, these beneficiaries got this money, but I didn't get anything. But they got the money in the beneficiary. They didn't get it in the will. Well, I didn't get anything in the will. Well, you can't confuse the two because they're two different legal documents associated with that. And you have to communicate that to the heirs and say, well, that's the way they wrote it out in terms of their wills and beneficiaries. And I'm sorry if you felt that you didn't get us enough. Confusing probate assets with beneficiaries. I don't like to talk about that. Not collecting the estate funds into an estate account. One of the very first things that you should do as a executor is you should get an EIN number and set up a bank account and move all the monies from their checking account into this estate account. It's one of the very first things that you should do on that. And I have a list, but I don't think I have time to go through the whole list of all the things that I had to do for the 6 different estates that I dealt with on here. Getting help from friends and professionals, had a lot of that in terms of not me as an executive, but my heirs would say, well, my friend says that I blah, 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 and they don't know what they're talking about, their friend. And you have to kind of be nice about it, saying that they don't know anything about what they're talking about, but nevertheless, you have to be nice about it to the heir and say, well, you know, it's this, not that, and et cetera. So it's an easy thing to say, but you have to keep the heirs involved in the process. Even though you're in charge as executor, you have to keep the heirs involved. And then the communication skill and the trust that you develop. Otherwise, you're going to get into all kinds of family problems that they don't like. They might not like it anyway because the will didn't offer them all the money that they thought they deserved, but that's a different story because the parents or whoever died did that. You can't ignore claims on the estate. Well, I have a bill, a telephone bill. You have to pay that telephone bill. So don't ignore all the claims that are associated with the estate. And a lot of times that's like a 90-day or 120-day period of getting those claims in. Otherwise, then the court will say, well, okay, all the claims are done. Everybody is supposed to make a claim on the estate, now it's done, and now you can pay all the claims on that. But it does take 3 to 4 months. Sometimes some states require advertising. I don't know whether Iowa requires advertising or not, you know, that this person died, and so therefore, oh, it does, okay, I just didn't know whether that did, because I moved here too soon. I've had this occur several times, not for me personally, but when I give advice to people that on number 11, self-dealing yourself. Well, I really like this car, and so therefore I'm going to pay $1,000 for this car, even though you know it's worth $50,000. And then the other heirs say, wait, you can't do that. And then that's when fights start on that. So don't self-deal. Say, okay, we'll put it on. Here's the internet market value of the car, and does anyone want to buy this car within the heirs, and et cetera, and try to do that. And the same with dealing with the tangible assets on your term. As an executor, don't say, well, you're going to do this and this and this. You're going to bring them together, and you're going to say, how about we do this, or how about we do that, or give me some other ideas. How do you want to split up mom's jewelry? How do you want to split up the coin collection that my dad had, type stuff? Or how do you want to deal with all the different personal assets that are worthless, but yet they got great memories in the family heirloom type mode of operation. So I gotta do quick. Estate plans. I'll do enough of that. The estate plans is 4 different documents. You have a power of attorney, healthcare power of attorney, which is being passed out, a living will, and advanced healthcare directives. And this will be emailed to you. This one is a statutory power of attorney form that you can fill out on your own. And this is more your assets. You know, your real property and your stocks and bonds, and who you want to designate under your power of attorney. if you're sick and you're in coma or whatever, and you can't deal with it, who do you want that person to, who would you desire to be your agent to look out for all of that stuff? So that's that form. And then the third form is the gift of peace of mind for yourself or your family. And it's a really long document, and it expands on this form that I'm going to talk a little bit about, that I handed out to you. This form, this is the simplest form I could find that's free, and you can fill it out and just say, okay, I want this person to handle my money, my medical conditions, my medical decisions. They have access to my medical files and whatnot, and they can make decisions for me in a medical time. And all you have to do is print your name, sign it in front of a notary, and you can go to your bank and get a notary for free. And that's the easiest way to do it. But if you don't like notaries, you can sign it in front of a couple of witnesses and do the same thing. But the notaries are so much easier than doing the witness round. I'm not sure that's doing it. And then if you don't like that document and you want to say, okay, I want to give even more guidance to that agent that's going to be my medical person, you can look at this total document, and they have 4 different situations in here. The first situation, the doctor has definitely determined that you have a condition for death, whatnot, and then do you want CPR, do you want mechanical breathing, do you want artificial nutrition, do you want pain, do you want antibiotics, do you want blood or blood products? And then the second situation is pretty much the same. You're in an accident or severe illness. The third one is you got dementia or that type of disease. And you can go through this document. And Jeff is going to send you this document. But I don't have time to go through all those assets. So the next thing is get your assets to the right people. Again, that is more of a trust document type thing that I'm going to talk about. And you can write trust documents and distribute your assets at the right time. Remember, probate is really, really slow, and maybe you want to do it faster. And you want to do it in privacy. Well, trust documents are private and they're fast. So that's the 2 benefits for the trust document. And then you want to deny access to the wrong people. I hope nobody ever wants to do that. But sometimes they don't like who they married, and so they want to make sure that the daughter that married somebody they didn't like, that the daughter keeps the money, but the married person can't get the money. That's a trust document type thing. Types of trust. There's a revocable living trust that avoids probate, which is good in my opinion in terms of probate. There's trust for minors. Kids are too young to manage money. There's a special needs trust. Somebody has a disability and you want to do that. My brother just recently died in December, and he was on a special needs trust for 50-some years, if not longer. Well, anyway, he died at 84. A gun trust, if you do have a collection of guns, you need a gun trust. A spousal trust or dynasty trust is a common trust where you give the spouse the use of the house until such time that the kids want the house, or the spouse dies and then the kids get the house, and then if the kids die, then the grandkids get the house, etc. That thing. There's a life insurance trust where you can throw it, you can develop that trust and you can put money into it, and then the trust will buy you life insurance, and then when you die, then the trust gets that life insurance, and then the people get the money from the life insurance, which will be tax-free type stuff. There's an asset protection trust. These are irrevocable trusts here where you can't change them. But the asset protection trust is one where you think you're going to get sued by some big deal, but you can't develop that until after the fact, because then it becomes illegal to do that type stuff. So most people don't do this. There's a crummy trust. I won't go into it because I got to get it on time. And a qualified personal residence trust, that's more one of this beach house or this mountain house. People have gone there for years to celebrate the family gatherings and whatnot. So you can put in a trust that the heirs will get it over time, at some time, until they all agree. But meanwhile, you'll pay all the bills associated, so you can still have those family gatherings in this family home type thing. So, living trust with estates, it's paperwork, but you got to fund it. Meaning, you set up a trust and you don't move any funds into the trust, you wasted your money in terms of buying the lawyer to develop that trust. So that's a common problem, more than you'd think on that. It doesn't protect you from debts that you might have, other than there is one, but it's not worth talking about. You failed to update your trust because over time, maybe all your executors have died, or maybe whatever has occurred. You just need to make sure that you keep track of it. You'd be surprised how many people don't keep track of what their trust says. And then you got to keep pace with laws. So that's hard to do sometimes. The myth of estate planning is for old people, it's for the rich, and it focuses on death. But as you can see on some of these documents that I passed out, part of estate planning is the power of attorneys. You're still alive, and you might recover from it. So that's part of estate planning. So it's not necessarily on death itself. And then, of course, as I said before, it's a mixture of assets and deep human emotions. Believe me, it's dealing with grieving people is really, really tough for me anyway. But I had to do it, and then the law. And then there's sometimes if you don't have any assets at all, don't worry about it. If you have only a couple $1,000 left, don't worry about it. Although I still think it will, because you never know what happens. It's better rather than have the will of the state do it. And then you're just too busy to do any kind of procrastination, to do any kind of this stuff that I'm talking about. So you need to get organized. You need to determine your net worth. You establish your goals. You hire competent professional help, lawyers, to develop trust if you decide that trust is your goal on that. And you need to monitor your assets. Nightmares of poor planning, you get sued, and then you have a car accident, you kill somebody, or worse, well, not worse, but the person is so injured that they have medical bills for the rest of their life, and your insurance should cover most of it, but what if happens, you get sued over and above the insurance company, and then you have even more, then they go after your assets and stuff like that. The same is true if you become disabled. What do you do if you're disabled and you can't pay your bills? Well, who's going to pay your bills for you? You die without naming guardians of your child. I hope everybody that has really young kids name guardians of their child, and then the guardians can also be the asset managers, or you can split it up and have an asset manager and a guardian on that. And the fourth one, if they're too young to manage money and they're adults, like 18 or 20, or like I said, I set up at 25, 30, and 35. because I just felt my kids were too young. Now, granted, they're old now, they can manage better than me, money now, but at the time, I felt that was needed. And then, if you go the probate route totally, and don't do any beneficiaries or don't do any trust results, you can have excess legal fees and costs. That's it. And I was hoping that I could get more time for people for questions, and I'm sorry about that, but community Sundays are tough to do. Started late.
But we can, anyone who stay afterwards.
Oh,
too.
yeah, I'll be
Definitely
staying here. So any questions, I went through very tough speed, and I agree. And next week is Mother's Day, and I doubt whether there's gonna be many mothers that want to see next week, but I'm gonna give next week's talk about the other aspect of tax giving and being able to tax efficiently give your money to churches or charitable organizations and stuff like that. So, and I'm experienced in that, yes.
Where do you get the form for the living will with the 4 different possible options? Is that online?
No, you're gonna be sent that, but that's also online, and it's this one.
Okay.
But you're gonna be sent that, Jeff is gonna.
Yeah, Jeff is gonna.
Jeff will send everybody that's come to this session, he's got your names. I don't know how he gets your names, but that's a different, but that's a different story. And he's gonna send you that one. And that's a more detailed, very long, type thing, so.
With 6 deaths in my family, all of this resonates with me.
Oh,
All
yeah,
of it.
yeah.
All of it. And I can tell you, I had a health power of attorney. When you get the death certificates, get mucho death certificates.
Well, nowadays, that may be not true.
Okay, good.
And the reason is that you still need to get a certified copy of it. A lot of places will just say, well, just email it to me, and they'll accept it. Now, some banks are a little picky, and they'll say, no, I need to see that raised stamp of the, and so, but anyway, because death certificates are like $25 a piece.
Yeah.
And you get 10 of them, that's $250, and if you can get by with just one. Now, my brother just died, and I got by with just one. And they sent me in just emails, say, oh, just email. So I was really shocked by that, because in my earlier days, I had to give everybody this certified death certificate. So it's changed a little bit, but.
With the AI out there, that may change, just given how easy it is to make things look like it's legit.
Joan, go ahead.
I'm not exactly sure what the word probate means.
Well, probate means that you will go to a court called a probate court, and that means that a judge then will look at the will, make sure it's valid, look at the executor and approve all this stuff before you can do anything as an executor. And then they have certain rules that they have to follow, maybe advertising rules to be able to advertise for the debt that you might have, to make sure that you captured all the debts that the person that died had, etc.
So do you have to go through that?
You have to go through a court, yes, ma'am. You have to do that, that's probate. You don't want to do that.
If you ever will.
You don't want to do that, that's why I like beneficiaries, and that's why I like trusts, because you don't have to go through probate to do all that. Plus, you have to pay a fee. Now, you could, if you write your will yourself, there's a 1% to 2% fee associated with surety bonds, so that the bond company then says, well, you're a good guy, and if you mess up, I'm going to sue you, but I'll protect everybody else. That's a surety bond. That's pretty simple, but nevertheless, that's the bottom line of it. But you don't want, but you can bypass that and not have to pay for the surety bond if you have the will that the executor doesn't have to pay for that type of stuff. And that's 1 to 2% of your assets in your trust. Yes, ma'am.
I just had a question on the guardianship. Is that in your power of attorney, or is that in the will? Or is that something that you put in multiple places?
Yeah, guardianship is not in the power of attorney. It could be in a trust document and not be part of the will, or the trust document could be part of your will. It's called a testamentary trust, but that confuses the issue. But it could be part of the will itself on that, but I would rather put it into a trust. But you have to pay a lawyer, but then again, you have to pay a lawyer for a lot of different things.
Chelsea, it can be totally separate. Like we have guardianship of our daughter who's on the autism spectrum, but we have to pay an attorney every year to renew that.
Gotcha.
Yeah, so, now there is one, trusts have trustees and not executors, and they're called trustees. There is one trustee where I would actually go to a corporate trustee, and there's nonprofit organizations that have that, and that is for a special needs child, because they have to keep pace with the laws associated with, which change constantly, the laws associated with getting government benefits versus the benefits that the trust can then give, but still maintain those government benefits that the special needs child has. And it's really hard for a trustee to keep pace with that. That's why they have, organizations that do that for free. Well, maybe not for free, but they're nonprofit organizations that will try to do it for a minimum amount of money.
This may be off a little bit, but a quick deed, if you want to do it before you're dead, and does that have to be acknowledged in the will? Or?
Oh, no. Once you die, whatever is left, and quick deed would mean that it's no longer part of it, and so it's not part of the, so you can do it. But you got to be a little bit careful in terms of timeliness of it. You can't die and say, well, I've got quick deed in the works, but once you die, that's it.
That messes with your Medicare and that type of.
Well, yeah.
I mean,
They used to have trusts associated with Medicare, or Medicaid, I should say, where you don't have to pay the assets, but they changed the rules now where it's a 5-year look back. And there's not very many people that do that anymore. And, 5 years from now, say you're my age, 80, or in the 80s, or 5 years from now, who knows what I might need 5 years from now, and I might be dead. But you can do it. You can set up still a trust, but where the Medicaid people can't then go back and try to get the money to pay for the Medicaid. But the other problem associated with the Medicaid thing is that if you do that, there's a lot of nursing homes and there's a lot of assisted living places that will not accept you if you just have Medicaid by itself. But they will accept you once you get into the place and you pay on your own, and then they will accept you after the fact, I guess.
When your assets are.
Yeah, when your assets are gone, they will still accept that.
Okay, that's why I was trying to protect a home from, if you quick deed it, protect it from having to use that.
Yeah, a quick deed will do it, but they'll have a 5-year look back.
Yep. Illinois had 10.
Well, yeah, every state is different, but.
We did a Lady Bird deed.
Yeah.
I'm sorry, I couldn't.
Lady Bird.
Yeah, Lady Bird
Deed.
deed, yeah. But every state is different, and I don't know.
Yeah, every state, yeah. There's a Lady Bird deed.
Yeah, well, I know. I did a quick claim deed with my wife just recently. I mean, I've got health issues and so forth, so we just decided it'd be easier, better, so she doesn't have to deal with it. And also, there's nothing in my estate whatsoever now, and it's all with her, and so there's no probate issues whatsoever for me personally.
Well, let's close in prayer. If we have more questions, Howard will be here. He's here, he's in the church, he has expertise. He's not going away.
And I'll see you next week.
Yeah, right. Heavenly Father, thank you for the Holy Spirit that is in the room with us, among us, and with us. In your Son, Jesus Christ, the power of your love. Amen.